Before we begin, a quick note. I'm not an attorney. I work with Eric K. Johnson, a Utah divorce lawyer, and I'm sharing this general educational information he prepared about family law issues that come up in Utah divorce cases. This video is about the 10-10 rule, myth versus reality in military pension division. If the marriage didn't last 10 years, you can't touch my military retirement. That claim is common in military divorces. And it's wrong. The 10-10 rule does not determine whether a military pension can be divided. It determines only how the payments are made. Here's the key point. Even if a marriage lasted less than 10 years and overlapped less than 10 years of military service, a court can still award a former spouse a share of the retirement benefits earned during the marriage. The difference is simply how the payments are delivered. When at least 10 years of marriage overlap 10 years of creditable military service, the Defense Finance and Accounting Service, DFAS, can send the former spouse's share directly. But if the overlap is less than 10 years, the court can still divide the marital portion of the pension. The service member simply makes those payments directly instead of DFAS sending them. Courts determine the marital share using what is often called a time rule formula, comparing the months of military service during the marriage to the total months of service. Only the portion earned during the marriage is subject to division. So, the real question is never whether the marriage lasted 10 years. The real question is how much of the retirement was earned during the marriage. The 10-10 rule changes the payment mechanics, not the spouse's potential entitlement to a share of the marital portion of the pension. This rule is often confused with the 20-20-20 rule, which relates to continued access to military benefits like TRICARE. That rule also has nothing to do with dividing the pension itself. So remember, the length of the marriage does not determine whether a military pension can be divided. What matters is how much of the retirement was earned during the marriage. Understanding that distinction allows divorcing couples to negotiate based on facts rather than folklore. And it helps prevent lopsided settlements, unnecessary litigation, and missed opportunities to secure a fair financial future.